Good evening. I'm Andrew Christie. I hold the Chair of Intellectual Property at Melbourne Law School, and I have the great pleasure of being the host of tonight's event. We're meeting tonight on the lands of the Wurundjeri people of the Kulin Nation, and on behalf of all of us, I pay our respects to their elders past and present. And on behalf of the Institute of Patent and Trademark Attorneys of Australia, IPTA, and Melbourne Law School, I welcome you all to this event this evening. When I say I welcome you, I mean not only those of you whom I can see in front of me, and it's a great crowd in this lecture theatre tonight, but also those of you who are watching this on the online streaming, and we know there are a number of you doing that. So to those of you physically present with me here and those of you whom I can't see but who can see me online, a very warm welcome indeed. Thank you for coming. I want to add one other very sincere introductory comment, and that is to say that the event that we have tonight is not only an IPTA Melbourne Law School joint event, but has been very generously supported by a number of other organisations, the key IP stakeholder organisations in Australia. IP Australia, AIPPI Australia, FICBI Australia, IPSANS and LESANS. Those five organisations have been good supporters of the Gurry Lecture Series over the years, and we're delighted that they've maintained their support. Quite simply, their support enables us to bring you this event and take it to other cities in Australia as we do next week in Melbourne and Brisbane. So thank you very much to those five organisations for your generous and much valued support. I know through having looked at the registration list for this evening that many of you have come to many of the Gurry lectures in the past, and I'm very grateful for your continued attendance and presence. I'm going to ask you just to indulge me a little bit, because I know you know the history of why we're here tonight, but if I may, for the record, just place briefly on it the fact that this series of annual public lectures on intellectual property was established in 2009. It was established as a result of the vision and generosity of IPTA. IPTA and Melbourne Law School joined forces to offer an annual public event, and we were delighted when the first presenter, Francis Gurry, consented to let us name the series after him. In 2009 we took a bit of a punt. Francis Gurry had only just then become Director General of WIPO, but we punted that he would have a very successful first term, and indeed, as happened earlier this year, be re-elected for another 6 years to head WIPO, and that he would have a very successful second term as well. And I think we can say so far so good. That is indeed the case. He's re-established the integrity of the organisation, re-established the credibility of the organisation, and reinvigorated the activities of the organisation. We have already, in his first term, 2 international treaties, as you know, on audio-visual works and protection of people with visual disability accessing copyright material, and various other initiatives that should bring fruit in his second term. So we believe that the distinguished alumnus of this law school and a distinguished Australian in the international sphere is indeed an appropriate person for us to name this distinguished lecture series after. When I begin planning for this event, one of the earliest things I have to do is produce a marketing flyer, and I go on to our pro forma document and I start filling in a few boxes. First box I have to fill in is the name of the speaker, and that was easy. I knew who our speaker was. The box immediately below that is the speaker's position, and I stumbled straight away. Unlike previous presenters of the Gurry Lecture, Alison Brimlow, for whom I simply put President of the European Patent Organisation, James Love, Director of Knowledge Ecology International, Robert French, Chief Justice of the High Court of Australia, Francis Gurry, Director General of the World Intellectual Property Organisation, I stumbled when I got to the box that went under Jeremy Phillips's name as to office, if you like. Indeed, he holds no single office. He holds a portfolio of roles and responsibilities. The fact that I stumbled filling in that box was not due to a surfeit of initiatives that he's engaged in, but due to an excess. I had a wealth of choice in front of me. I could have chosen from the range of activities that would be considered academic. And indeed, Jeremy has had a distinguished academic career. He's held lectureships at Trinity College Dublin, Durham University, and then in a number of stints at Queen Mary in London. And indeed, he remains a professorial fellow at Queen Mary to this day. I could have chosen from his activities in the area of consulting to the legal profession. From 1994 through to 2007, he was an IP consultant to Slaughter and May, and since 2007 has been an IP consultant to Olswang, London. I could have chosen from the very deep set of responsibilities that we might call publishing, involvement in the publishing industry. Many of you will remember well Trademark World, Patent World, Copyright World, those magazines that Jeremy was the founder, editor and publisher of. And in another stint later on, perhaps even better known or remembered today, managing intellectual property. That too, he was the founder of that very well-known industry publication in IP. But his involvement in publishing is not just limited to the business or commercial sector. He has had and continues to have very substantial roles in academic publishing. To name just a few, founding editor of the European Trademark Reporter series and founding editor of OUP's Journal of Intellectual Property, Law and Practice. And I could have chosen from his responsibilities in the area of social media. Amongst other things, he coordinates social media for Marks, Marks being the European Trademark Owners Association, and also in 2003, and perhaps for many of us better known, he founded IPCat blog, a very well respected and well followed blog, I think more than 9,000 followers at the moment, and a key resource for looking at IP developments. But none of that would fit in a box. And indeed, Jeremy Phillips, that's because Jeremy Phillips doesn't fit into a box. The exhortation that many of us are given by others, which is to think outside the box, is one that we couldn't give to Jeremy. How could you ask somebody who's not in a box to think outside it? And if you think about it, if you wanted somebody to tell you, given that IP is in transition, what the big picture is, you would be wanting somebody who had a perspective across the areas of academe, of legal practice, of business, and of social engagement. And I don't think I could offer to you anyone better placed to do that than our speaker tonight. So all I need to do is ask you to join with me in welcoming to the podium to deliver the 6th Francis Gurry Lecture on Intellectual Property on the topic IP in Transition, Desperately Seeking the Big Picture, Jeremy Phillips.
Good evening. Thank you, Andrew, for your kind words of introduction. Thank you, University of Melbourne and the Institute of Patent and Trademark Attorneys of Australia for arranging this series of annual Francis Gurry Lectures in which I'm so privileged to take part. I'm delighted to have a chance to contribute to these lectures for at least 2 reasons. First, I've known Francis since the days in which I was a young lecturer, suspiciously eyeing this talented fellow academic as a potential rival for the posts which I assumed we'd both be fighting for in the future. As it turned out, our careers' paths diverged quite substantially, thus enabling us to use our particular interests to complement rather than to compete with each other. Francis took the high road, becoming Australia's first Director General of WIPO, giving him a commanding view across the Swiss Alps, embracing the breathtaking vista of intellectual property in all its glory. I took the low road, examining the state of intellectual property as viewed from the perspective of 2 fictional cats. Both cats, I might add, are huge admirers of Francis, of all he has achieved, on the big stage of intellectual property, and the dignity and generosity of spirit with which he has demonstrated his abilities to do so. The second reason why I'm delighted to be participating in this series is not entirely unconnected with the first. Like most people, I very much enjoyed Francis Gurry lecture, Rethinking the Role of Intellectual Property. And I needed no reminding of how good it was. This was pointed out to me by endless emails from kind friends saying, "Congratulations, Jeremy, on being appointed this year's lecturer. You've got a hard act to follow." Handicapped as I am by following a hard act, I'm doubly handicapped by the news given to me only a few days ago by Andrew that I'd better not make too much use of PowerPoints. So it seems audiences in the Southern Hemisphere are unduly distracted by them. So to make sure that this weapon of mass distraction isn't too heavily used, I've deleted a number of illustrations of provocative patents, delectable designs, titillating trademarks, and, well, never mind. I've also taken the opportunity to eliminate a lot of facts, case citations, statistics, statutory provisions, and jokes, assuming statutory provisions and jokes to be two categories and not one. Friends and colleagues, what I'm going to be talking about today is not facts. I'm talking about feelings. When we're desperately seeking a picture of intellectual property, a big picture, where it stands today, what I want to know is how IP feels to us as users of the system in all its glory. The snapshot I want to take is quite a visceral one. Now for something which is not so much a disclaimer as a warning. This lecture does not offer one big narrative. It offers a lot of short points in no particular order. And in this sense, it rather resembles life in general, where our experiences and our understanding come to us in no particular order, and we have to make sense of them. We don't have a big picture of intellectual property, which we can cut up into neat little pieces and look at. What we have is a load of fragments which we're trying to assemble into that big picture. And in taking my approach, I'm drawing unashamedly on my own personal experiences and my feelings in result of them. Over the years, I've done a lot of things which are associated with IP, not in the official sense of being this and being that, but in a doing sense. I've written books. I've had to publish them myself when publishers have gone belly up just before they were supposed to come out. As an editor, I have edited other people's works, sometimes to the extent at which I felt that I really wrote them myself, sometimes to the extent at which I was waiting to be sued for maliciously mutilating the work which has been sent to me. I've commissioned other people's work. I've hired people to create works. During a 2-year stint with Interbrand, I was involved in brand creation, thinking up trademarks, then discovering why businesses didn't want them. As an IP owner, I've asserted my IP rights and threatened legal action. As a consumer of other people's rights, I have faced legal actions for copyright infringement and passing off. I've been a client, an independent consultant, an expert witness, an arbitrator and a mediator. I've negotiated licenses on behalf of others and myself, and I'm the proud owner of a community trademark. And as a former academic, so I'm a bit lapsed these days, in an institution which had an unsupervised photocopier just 2 meters away from my office door, I don't need to go any further to explain that one. So, why do we need the big picture? Is there a problem? Unless we have a picture, and look at the picture, we don't know whether the problem exists or not. Francis Gurry says, let's rethink intellectual property. We might want to de-think it or not think it at all. So let's have a look and see what's there. IP has had an interesting experience over the last 40 or so years. It's gone from being an unknown subject to a nice little money spinner in a niche area for practitioners, to, within the last 10 years or so, a toxic term. for something which people really don't like, which people are really suspicious about, is now associated with other toxic terms, like biopiracy. It's associated with the control of knowledge and the suppression of information. It's associated with brand exploitation. Some of you may have read Naomi Klein's excellent and quite misguided dissection of brands in No Logo. IP is also associated with the reduction of peasant farmers to a state of dependence on patented seeds, fertilizers, pesticides, which they can't afford. Patents kill, but medicines cure. And people nowadays make no connection between the two. Opposition to the anti-counterfeiting trade agreement, ACTA, brought tens of thousands of people onto the streets in Warsaw and other cities in Europe to complain about the damage it was about to inflict on the internet, even though, as it turned out, most of the people who took to the streets had never actually read its largely unexciting provisions. So in short, there are a lot of people out there who don't like us because they don't like it. They don't want it, they don't use it, and they say so in no uncertain terms. But the it which people criticise, the it which people hate, the it which makes people's blood boil, is the same it which we love and cherish and work with. And we're both looking at the same object. Or are we? Now, in looking at IP, it's very easy to take a perspective and say, well, IP is what it is because of what it used to be, taking a historical approach. I don't think we want a historical picture. History is the plasticine of choice for people who like to manipulate the past for their own future purposes. We always hear about the famous story of King Dermot of Tara and how copyright began with the motto, to every cow its calf, and to every book its author, its copy, beg your pardon. This actually has nothing to do with copyright as we know it today. We hear endlessly about the Venetian Patent Act of 1474, which has also precious little to do with patents as we know them today. We're not governed by history. And to all intents and purposes, history started again in the mid-1990s with the birth of a searchable internet. So let's start from the mid-1990s and carry on from there. So forgetting history, what about a philosophical point of view? Should our big picture be framed by considerations such as the entitlement to control or benefit from the sweat of one's intellectual brow, as Locke might have it, or the satisfaction, the greatest happiness of the greatest number, as Bentham might have it, or on the control of the means of production and the fair distribution of wealth, as Marx might have it? I think the answer is no. Within the context of these philosophical analyses, we're always dealing with something which is an ought and not an is. And it's unusual for a picture of an ought and a picture of an is to coincide and give us an accurate picture of where we are. Perhaps we should do what the economists do. I mean, there are now, I think, 6 economists working in the Intellectual Property Office in London, and they must be doing something. Perhaps they're giving us a picture. The picture based on economics is a very partial and inaccurate picture. It's not a big picture of intellectual property at all. That dismal science makes no account of the existence of moral rights or the irrational and unlawful behaviour of players within the system, and doesn't really account for the fact that the vast majority of registered intellectual property rights have no impact on trade or commerce whatsoever because they're never infringed and they're never used. That's something I should be referring to again later. So, what rights do fit into the picture? Not all intellectual property rights are really intellectual, but we put them all in the pot together. Perhaps we shouldn't have done so, but we've done so now. Just to give you some idea, the artist's resale royalty right is part of the intellectual property environment in which we live, work and practice. But what does it have to do with intellectual property? The right to get a proportion of the sum received in resale of an artwork is a right in the chattel. It's a right in the thing, not in the copyright itself. Should it be there? It is now, and it's part of our picture, but it doesn't really fit the model of something which is an intellectual creation. And we have rights within intellectual property rights, such as the right to exhibit a work. Once again, perhaps this is more of a chattel right than an intellectual property right. With the centenary of the First World War, we have major discussions going on at the moment in England about the right of museums to be able to put letters, original letters, written by soldiers at the front line to their loved ones back home, into glass cabinets so that people can see them. No, they say, this is an infringement of the right to exhibit. Is this where our intellectual property should be? It's part of where we are and what we're doing. But once again, the object of interest isn't the words so much as the embodiment of the words in the letter itself, the original article. It's a chattel right. What about rights in biological resources? The Convention on Biological Diversity and the Nagoya Protocol have a good deal to say about bioprospecting and biopiracy, taking somebody else's biomaterials and developing them, exploiting them commercially, patenting possibly processes involving them, or products, incorporating them. But is this an area in which sentiment has been allowed to take the place of cold, clear logic? Should this be part of our intellectual property environment? Should people have a right to stop people using biological material just because it happens to be on the patch of land which they control? We say yes, because we're afraid to say no. It might be right to do it, it might not. But are we simply saying, yes, you can have these rights? Because what we're actually doing is giving a condescending sop to countries instead of spending time and effort in investing in their education, training and capacity building. Much the same can be said about religious, cultural, medicinal and other traditional practices, where the case for respect and protection is an extremely strong one. But is this something which is more properly under the umbrella of WIPO and intellectual property? Or is it something which should be within the remit of another United Nations agency, such as UNESCO? We can think about it. And within the family of intellectual property rights, well, there are things which are so close to our hearts that we take them for granted, which don't really have an intellectual content at all. Questions can be asked about the inclusion of trademarks, geographical indications, designations of origin, and so on. There's no pretense that innovation or creativity lies at the heart of their protection. Tommy Hilfiger, Christian Dior, Champagne, Palmer, Stilton, these are valuable assets with massive goodwill. But the creativity and ingenuity that have gone into their success have been devoted to practically everything except the so-called and arguably pseudo-intellectual asset, which is the name itself. Anyway, having questioned this, we have to concede that there are some major elephants in the room. And let's just have a quick look at them now. From an intellectual property point of view, our picture must be framed by these elephants. One is competition law. Competition law is not intellectual property law. It does the opposite of intellectual property. It stops you from having winners and losers. It stops you from being able to exploit your intellectual property at the point at which you're really doing it very well, to the point at which you're getting substantial return on your investment and you're wiping out the opposition. So in Europe, we have to recognise that competition law is a higher value than intellectual property law. It's because there is competition law that we're allowed to have an intellectual property law, basically. And although it prevents intellectual property laws from being carried to their logical extent, perhaps necessarily so, it's always there in our picture, our big picture. Likewise, human rights. Human rights, such as the right to privacy, the right to publicity, to receive and disseminate information, are now taken so much for granted, it's difficult to imagine how in the 1970s, most of us in common law countries didn't really have a grasp of how these were going to impinge upon intellectual property rights at all. They have different values, they have different parameters, but they're there the whole time. The third non-intellectual property intruder on our big picture is the biggest of them all, which is the public domain. There's vast, ubiquitous supply of information, which is usually forgotten about altogether. But it's so important because it's the ultimate resting place for so many of the intellectual property rights that expire, and so much intellectual content which never even goes into the category of registered rights. Some elements of the public domain can be clawed back into private property. We see this from time to time when secondary meaning is given to a generic term and it ceases to be generic anymore. It's been captured and become a trademark. And we see it with companies that are able to... No, we don't. I'll save that bit for later. We see it also in patent law, where second medical uses of known substances may get a second lease of life as intellectual property. But on the whole, once something goes into the public domain, it stays in the public domain. And that's a huge asset which frames our big picture of the things which are intellectual property. Now, at this point, you realise that I'm doing a lot of generalising, and we have to generalise because we have to work from our own specific experiences of intellectual property and understand what they mean to us, what they feel to us, and we assume that they apply elsewhere. And it's a natural intellectual process. If the first, second, and third cats that you stroke will purr, you will assume that all cats that you stroke will purr, or at least there's a rebuttable presumption that they will. But if the first, second, and third cats that you stroke scratch you, you will assume that all cats will scratch you likewise. So we're all the prisoners of our own experience. And given that we are, and we work in different areas of intellectual property, there are lots of different variables which affect our own experiences, our own perspectives, our own demands, what we'd like to see changed, what we'd like to see improved. For example, the intellectual property we experience varies as between different types of intellectual property right. Patents breed neuroses. They're hard to get, hard to protect, hard to administer, hard to interpret, and they only live for a relatively short time. Like the Tamagotchi, they can die the moment you turn your back on them. They're gone. Copyright in authors' works, however, is the complete opposite. It floats painlessly into existence, seems to go on forever, spreading into jurisdictions you never imagined and certainly can't spell. Secondly, the IP rights that we know and love also give a different driving experience. Rights which have not yet been used, rights which have not, in intellectual property which have not yet been published, tend to have a much tighter, much better sort of protection. Trade secrets, for example. Copyright works before they've been published have a much better level of protection than things which are open and known and used. Once patents are out there and they're published, then defences, exceptions, bowler exceptions for research exist. Compulsory licenses can be granted. So too in copyright. Your fair dealing, fair use provisions don't really affect unpublished works, but once they're out in the open, suddenly your work is a target. It can be used, it can be parodied, all sorts of things can happen to it. Thirdly, IP varies hugely as between different commercial and industrial sectors. In the ICT sector, information, communications and telecoms, patents are more likely to have a shorter lifespan, as standards, technical standards keep changing, and patents in the ICT sector generally hunt in packs. One patent by itself isn't very useful, but when you've got a whole portfolio covering an entire technology, then they're quite useful. The pharmaceutical sector is the exact opposite. It conforms much more to the one patent per product model that the patent system was originally conceived to protect. And patents for pharmaceutical products tend to have a much greater degree of longevity, so much so that in many jurisdictions it's possible to get supplementary protection certificates which carry their protection on even after other patents would have died. With copyright as well, the user experience in different sectors is vast. The way in which copyright in Harry Potter stories works will vary quite substantially from the way in which the copyright in the software that runs your PC will go. They feel different, they look different, the ways in which they're infringed are different, and your feelings about copyright will be very different depending on whether you're J.K. Rowling or part of a team of 200 people developing some operating software at Microsoft. Likewise, IP feels different depending on whether you own it, whether you're a licensee to it, whether you are a person who is leaning on somebody else's IP and infringing it. And in professional terms, the profession is divided up to some extent between those who are involved in getting the rights. They file applications to get patents, trademarks, designs. They oppose other people's, they seek cancellations, they deal with offices. Then those people whose experience of IP is in commercializing rights. They're involved in licensing, sponsorship, endorsement, franchising. And those people who are principally involved in litigating them, whose view of intellectual property tends to be very much more pathological, because if you're a litigator, you only see the problems where things have gone wrong. You don't see all the things which have gone right. And I think that can give a tremendously distorting view. And I might add that the same intellectual property right can be treated in very different ways in different countries. And you often hear people say, well, in Spain they don't treat trademarks properly, or in Germany they really treat patents very well. And you look at the basis of this, and you will see that possibly shades of judicial decisions have made it a slightly more comfortable or a slightly less comfortable jurisdiction in which to enforce or to exploit commercially one of those rights. Now, we've got a fascinating environment for intellectual property in which there are an awful lot of players in it, internationally, regionally and nationally. So you get a quick example. Well, WIPO is the UN agency which is officially responsible for intellectual property. There are plenty of other UN organisations which have their own IP policies as well. UNESCO still administers the semi-redundant Universal Copyright Convention, for example. But UNESCO's interest is not on providing systems for getting intellectual property. UNESCO's interest is in protecting and promulgating education, science and culture. And from UNESCO's perspective, intellectual property rights which allow rather than prevent those things from happening are what they would like to see best. UNCITRAL, the United Commission on International Trade Law, has an interest in intellectual property as well. It spent the last few years working on a code on securitization of intangibles, which would involve having a register of intangible rights that lenders could refer to when seeking to protect their interests, quite forgetting or not noticing that registered intellectual property rights exist under the intellectual property laws of most nations in the world. UNCTAD is interested in trade and development through bringing down tariffs and barriers to trade. And therefore, it's interested in intellectual property not being used as a means of keeping goods out from one country to another, and they're being imported, and so on. Outside the United Nations family of organisations, there are other big international bodies which have a say in intellectual property. The World Trade Organization administers TRIPS, which says if you want to be part of the world community of businesses, so countries which have businesses which trade with each other, then you've got to have at least minimum standards of intellectual property protection. Interpol is naturally involved with intellectual property from the point of view of trying to track down people who are committing criminal infringements involving intellectual property on an international basis. And of course, there's the Secretariat of the Convention on Biological Diversity. They've all got an input into IP. Regionally, we see the same. In Europe, we have different organisations in different countries which deal with different bits of intellectual property. And in the UK, the Intellectual Property Office is notionally responsible for all of intellectual property, but in reality it isn't. Plant varieties rights and geographical indications come under the Department for Environment, Food and Rural Affairs. And a lot of copyright and media policy comes under the rule of the Department of Media, Culture and Sport. And there are some 22 government departments in the UK that have their own IP policies of one sort or another, and their own people who specialise in it, and their own people who do it. It doesn't matter, actually, if there are lots of different people and lots of organisations dealing with intellectual property. From our point of view, we want to know, are they talking to each other? And more importantly, are they listening to each other? On the subject of organisations, and never want to be controversial, I thought I just might mention a few organisations who have a big impact on intellectual property, but they don't necessarily have anybody to answer to for what they do. You might be surprised to see the European Patent Office there as a very respectable organisation. But those of you who have read the social media and are increasingly reading the non-social media as well, will be noticing that something is amiss in the state of Eponia, and that the EPO seems to become something of an ungoverned or ungovernable juggernaut, chugging through the centre of Europe, causing devastation in its wake. It seems to me, on a purely personal basis, that for as long as the EPO carries on receiving quantities of patent applications and making more money than it spends, nobody on the council which oversees it is going to do anything about it. But it's causing a lot of ripples when you have an organisation which is apparently answerable to no one, is non-transparent, and which causes serious professional people to ask questions like, why do the different boards of appeal within the EPO apparently have different practices and procedures? Why are they not consistent? Why do they seem to be doing their own thing? And what is happening? And why are their decisions so important and influential when, technically speaking, the boards of appeal aren't even courts? They're only really administrative filters through which European patent applications are rectified and purified. We also have the International Olympic Committee, which charges through countries every 4 years and imposes upon them requirements to prevent all sorts of ambush marketing, which are not part of the normal indigenous intellectual property law, and insists that it's absolutely vital for their protection. And FIFA, the governing body of world soccer, is doing exactly the same thing. And the question must be asked, if ambush marketing is such a dreadful and wicked thing, and this is a big question because most consumers seem to enjoy it, and most businesses would rather do the ambush marketing anyway, because it's businesses that do the ambush marketing. Why, if it's so important to stop it, why is it not stopped everywhere at all times? And if it's not so important to stop it, then why are FIFA and the International Olympic Committee allowed to get away with it? WIPO, Inter, and other organisations involving rights owners don't seem to be pressing for an international treaty on ambush marketing. So I'm a bit uncomfortable about this one. Anyway, there are also plenty more bad boys on the block. Just to run through them in no particular order. Patent trolls. The term is not a terribly helpful one because it involves anybody who is effectively owning a patent but not manufacturing out of it. And that could be nasty people who buy a patent in the hope that somebody will land on their technology and they can charge them a rent, to people with spurious patents, which nobody quite knows what they mean, and they say, it'll only cost you a small amount of money to pay us a license and then we'll go away, to university research institutions that, for obvious reasons, don't have their own manufacturing capacities, and they can only make money through licensing their patents. But they have a very bad name collectively, and various bills have gone through Congress in the States to try and regulate or eliminate the effects of patent trolls. There are copyright trolls as well. Do we excuse them or do we excoriate them? Some people regard copyright collecting societies as copyright trolls, which I think is a little unfortunate. Once again, if you land on their little bit of the monopoly board, they expect you to pay. And people forget to look behind the copyright collecting societies at the people for whom the copyright is being collected and for whom litigation is never an appropriate option in their own name to try and get the relatively small sums which they would seek through licensing of their works. Now, in the context of copyright trolls, let us not forget Getty Image and Bridgman Art Library and organisations like that who do a wonderful job of employing people at a paralegal level to basically patrol the internet and to patrol everything else that they can find in the hope of finding somebody who's used one of their images and then sending them bills for astonishingly large sums of money. I don't know what happens to the people who don't pay. Also in the bad boys category are any named pharmaceutical company that actually produces medicines that cure people who can't afford them. These are deemed automatically bad boys, regardless of the expense and the effort they've gone to producing their works. This is why we get a bad name. Luxury brands are also bad boys on the market because they like to keep prices up, and they've persuaded the European Commission that part of the brand experience is having to spend a lot of money in order to buy the product. You know, people would think the perfume wasn't so fancy, they wouldn't get a kick out of it if it was cheap. Now, it's quite interesting. I mean, most people that I know don't actually buy their own perfumes. They wait for somebody else to buy it for them. And the person who's buying it for them is actually very happy to buy it cheaply. And you save it up to you're going to a duty-free, or you want to find some other useful outlet. The Court of Justice of the European Community said, no, you can't do this, it's terrible. The fact that you might be able to go to an out-of-town cheapo store and buy your Chanel No. 5 from a stand near where sides of cured ham are being sold. It doesn't fit in with the nice community notion of free trade. We haven't finished with bad boys. Brands that steal culture are not very popular in some quarters. Pocahontas used to be an Indian princess, a real live person. She is now a captured Disney character. Whatever you do with Pocahontas, even if you're not treading directly on Disney's toes, they've got a huge portfolio of Pocahontas trademarks, and they'll be very interested in what you do. 2 weeks ago, we learnt in England, and this is a remarkable feat, of a company which patented a trademark for Lady Godiva in the UK, which enabled them to stop a pub in Switzerland calling itself Lady Godiva. Once again, Lady Godiva is national property in the United Kingdom. The story was, of course, wrong, but people don't like to see public characters being seized in this way. Companies with no sense of humour. Louis Vuitton fits the bill perfectly. When they sued the manufacturers of a soft dog chewing biscuit for Chewy Vuitton, they had themselves only to blame. And when they went after the painter who did the Darfornica picture, I mean, you might never have noticed that there is a Louis Vuitton pattern, registered community design on the bag of the little boy in the middle. And most people never really noticed it until Louis Vuitton decided to sue for design infringement. And the result was because everybody noticed it and thought it was a really good painting. Anyway. And finally, tobacco companies, by seeking to argue their case that they should be allowed to package teach their goods the way they like by reference to the misappropriation of their intellectual property. Also, bad boys on the block. This is an interesting one because in Europe, now that we're getting plain packaging and brands are being squeezed and pushed back and almost eliminated, people are saying, well, if we could do it to tobacco products, we should be able to do it to alcohol and calorific products which small children eat to become obese. So this is an interesting battleground. IP at the margins. I'm going to run out of time. So what I'm going to do, I'm going to fast forward on this bit. Will you forgive me? Yes, good. Okay. I'm going to fast forward to that. Gothic horrors. I think this is something we ought to talk about. Because we are so familiar with the IP system, we tend to miss things which are blindingly obvious to people who are not part of the system. Things which are really defective. One of these is the time and effort taken to establish that trademarks or signs are actually confusingly similar. In Europe, by the time you get from the trademark application to a ruling of the General Court that two marks are either confusingly similar or not, takes on average 6 years. And you think, well, you look at the marks and you can guess what the result is about 99% of the time, even without knowing the law. Because the reality is that the law has been framed in a way which pseudo-objectivizes the subjective view that you have that something is confusing to something else. And if you think it's confusing, the chances are that other people think it's confusing as well. And although they've got a whole series of rules, basically you can guess the answer. What business wants to wait 6 years to find out whether it can use a trademark? It doesn't make sense in consumer terms, in commercial terms, in any terms. And we've just taken it for granted. Yeah, it's going to be a decision of the opposition division, the Board of Appeal, the General Court, and so on. And this is going to grind its way through. A team of monkeys being arbitrarily given the chance to decide which mark they like better might have done a better job. At least businesses can get on with their business once they know that they can or can't use a mark. Also, something we take for granted, every country has its own IP laws. They're all different. Therefore, if you've got a dispute with somebody else, as in the Budweiser case, then you have to sue in every country in the world. It makes perfect sense to sue in every country in the world and to take decades over it, over 100 different countries. It's a Gothic horror. Consumers know that there are two different Budweisers, and they sometimes want to buy the one and they sometimes want to buy the other. And they can't understand why one has to go through so many different litigations. And in some countries, the brands are confusingly similar. In some they're not. In some there's concurrent honest use. In some there isn't. In a way, the parochial nature of intellectual property law is less sophisticated than the perception of the consumer. Anyway, let's look at money very briefly, because money goes very quickly. We forget sometimes that money has a very important role to play in intellectual property. Governments are now getting the idea. Let's have a monetary policy with regard to IP. Patent boxes. If you can put your patent in a box, metaphorically speaking, the income generated from that will get special tax treatment, make it more useful for you to keep your patent portfolio in one country than another country. The German government have said patent boxes are evil because they distort trade and commerce within the single market. A lot of other countries say they're really good because they encourage people to exploit patents commercially and to know they'll get something from it. Film production tax relief is a thing which a lot of countries are now going in for, to encourage countries to have their own indigenous films instead of always having to watch the American ones. And there are R&D tax breaks in some countries as well. But we don't use the same technique for encouraging other positive behaviour on the part of IP. For example, the cost of pursuing infringers, particularly criminal infringers, it can be very difficult, very expensive, but we don't say to people, the money that you spend enforcing your trademarks, your patents, we will actually give you extra tax relief on this. And it's a shame because governments get the benefit when infringers are stamped out and trade is lawful because they reap the value-added tax on all lawful transactions. And it's worth their while to invest a bit of money in encouraging businesses to enforce their own intellectual property rights more thoroughly, rather than saying, we can't sue everybody, so we're only going to sue the ones that it's really cost effective to sue and hope the other ones will go away. There are wider issues in money, of course. IP is becoming an asset class. Attempts are being made to set up auction sites for intellectual property, generally quite unsuccessfully, but we're at the beginning of something big. Insurance of patent litigation is a fascinating subject. People think, well, it's going to cost a fortune if I ever have to go to court over a patent, so I want to get insurance. And insurance companies say, yes, we're very happy to insure you. But because patent infringement is so risky and so expensive, insurance companies want the same protection that they're offering to their policyholders. So policies tend to be extremely expensive and to exclude all the things you most worry about, and to have the extra threat that with the doctrine of subrogation, some insurance company is going to say, well, we actually have the right to settle this dispute, and we're going to grant a license to the person that you're suing. Heaven forbid that that should happen. It's not a good idea. Pressing on. So we'll look at some of the people who do settle disputes. Judges are a good lot of people to look at. Many countries now have specialist intellectual property courts and tend to enjoy the experience. Within the United States, Judge Diane P. Wood has taken a different view. She said, when you've got specialist judges that have come through a specialist bar, they won't be objective. They're chummy with counsel. They will make assumptions based on their own knowledge rather than on arguments. What you want is a judge who comes to the case with a fresh, untainted mind. My impression is that on the whole, litigants tend to prefer judges who don't have fresh, untainted minds, the judges who actually know about the subject. And those who advocate non-specialist judges, I would ask them, would they like to go to a non-specialist medical practitioner for any specialist? There you are. Okay, administrators. Say lots about administrators. I'm not going to. On the whole, the administration systems within intellectual property have improved immeasurably since the days of the internet. And paradoxically, the internet has done a huge amount to bring IP offices and their users closer while actually reducing the level of human contact. This is because so much of the information, so many of services are provided by the administration on a 24/7 basis. I can still remember the days when the IPO website services closed. You couldn't use them at any time when the office was closed. Fortunately, that idea that your search services and everything can only be used when the office is open has disappeared a long time ago. But it's actually very comforting to know that there are IP websites out there which provide you with information. You can't always get hold of somebody. You phone up at the office at 5:30 in the afternoon. If it's somebody in the private sector, they'll usually be there. If it's someone in the public sector, they may not be picking up their phone. But if you've got a website there where you can search, you can frequently ask questions or whatever it is to get your information, that's not so bad. There's an eternal triangle between IP owners and their advisors and colleagues, criminals, copyists and counterfeiters, and consumers. As my slide indicates, we have the legitimate sector. We invest in new products, new processes. We experiment to see which ones will work and don't work. And then we've got them. We sell them to the public with the best of intentions. And we share information. We have training schemes. We do everything we can. But criminals, copyists and counterfeiters who don't have conferences to go to, they don't have training programs, they don't have continuing education, they don't have specially funded events to assist them, tend to get the better of us most times. And this is because they have a big ally on their side, which is the consumer, who, unfortunately, all too often turn a very blind eye to what they're buying, or they specifically want something which is going to be a knockoff product. The market for imitation Rolexes is quite a buoyant one, and it's very sad. The IP professions, just mentioning them now, as between the different countries, it's a tremendous mess because there are no consistencies in terms of qualifications, training, professional privilege. There's a constant pendulum between the fashion of having your IP practitioners in-house and outsourcing them. And I think 4 times in my lifetime, I've seen a shift go from one to the other and back again. And I feel very sorry for IP professionals. On the whole, they tend to be amongst the most highly trained and highly skilled of legal practitioners, whether on the patent and trademark attorney side or whether as IP specialist solicitors. And they have to shout very loud to make themselves heard, I think, within the IP environment. IP as an academic discipline, just very briefly, there is too much bias within university circles, conscious or unconscious, against intellectual property. And I see this time and time again when I receive submissions of articles for the Journal of Intellectual Property Law and Practice. It's a dangerous thing. It's a bad thing. Criticism, which is fair and constructive, is always welcomed. But too often I see tired, snide comments about intellectual property in materials which are submitted to me, which don't come with any footnote and don't come with any credibility. I think we academics are causing a problem, not least because when our students come out of university and find themselves going into legal practices, the IP that they encounter there is a very much more positive and a very much more useful IP than the slightly toxic IP which many of their lecturers seem to be selling to them. So I think we ought to be conscious of our sometimes unconscious biases. IP policy making. Policymakers are fascinating people. Within the UK, we set off a trend in the rest of Europe now to call for evidence-based policy, but what we often get is the opposite. We get policy-based evidence. And this is a major misfortune. It's very frustrating when you actually go to the trouble of proving, and you even pay economists to do it for you, that there is no justification in economic terms for extending the length of copyright by another 20 years from in the sound recordings from 50 years to 70 years. And the next thing you see is that they're doing it. And you wonder, are you just calling out into a desert where there's no one to hear you? And the other thing is evidence is always economic evidence, because intellectual property is only now an economic subject. Morality of IP has been wiped out. If you go back to the 18th, 19th century, even the beginning of the 20th century, you'll find people talking about it being wrong to copy. It's being immoral to free write. They use moral words. You look through the European Commission's papers on intellectual property and try and find anything that says copying is wrong. And you'll be a long time looking, because it isn't there. Morality has been edited out of the big picture. Some big truths, lots of big truths. One which we sometimes forget is that IP is a means to an end, not an end in itself. If you can achieve the same end without using intellectual property, then it's not a bad idea. The surest way to get profit from your IP is to benefit from somebody else's. Terrible thing to say, but it's absolutely true. Identify a successful IP product, and then you either wait till it falls out of protection, you can make it too, or you could have a go at infringing it, or you can improve it, or you can buy the business that manages it. Most IP doesn't work. Most IP is not commercially successful. So there's actually a lot of commercial sense in the strategy of watching to see what does work. Everything is limited by money, and people tend to forget that. What you can do with IP in terms of building administrations, in terms of providing professional services, in terms of developing and exploiting new IP, part of the picture frame is the availability of financial resources, and we have to live with that. And human behaviour governs how IP works rather than the other way around, and there's no IP system that's so good that we can't screw it up. It's something, just take a little nothing of a subject, a little irrelevance. Like when you're filing for patent or trademark or design protection, and you're dealing with offices, there are these things called deadlines. Now, You read it, and it's there in the statute or in the implementing regulations or whatever it is, and there's a deadline. And now, what do human beings do? Instead of saying, well, the deadline is actually the last date by which something has to be done, the last date by which you have to respond to questions from the examiner, it's the last date. They say that's the target date on which it has to be done. And what happens as a result of this? I'll tell you what happens. We have last-minute responses. We have late responses because the last minute wasn't quite last enough. We have last-minute instructions from clients, and then the professional representative doesn't have time to go back to the clients to say, what did you actually mean? Or 3 pages of that fax didn't come through, because it's just gone. And what do you have then? You have practitioners who get very irate with examiners who are supposed to guess what it was that the client intended and which would be written into the claims of the patent, because there wasn't time to do it properly. And then you get the people who are even more irate because their colleague has gone off sick with stress-related illnesses, because instead of being able to do his work during normal working hours, he was up 3 nights running without any sleep, trying to do it in order to meet that deadline. And this is nothing to do with the law. This is just to do with humans and what we are and who we are. Can you imagine how much better the environment would be in IP if people just looked at that one small, almost irrelevant subject and treated it with respect? Oh, it's an interesting subject. Anyway, I want to know what the picture of IP looks like. What is our big picture? And I'm going to show you what the big picture of IP looks like. Are you ready? Yeah. It looks like that. Your starter for 10. Who is the artist who created that? Tracy Emin, very good. Your next question for 20 points is, what is the title of this work? It's called Tracy Emin's Bed. Right. And your next question for 30 points is, how much did it go for at auction in June of 2014? £2.2 million. So next time you make your bed, just bear in mind the fact that you're probably destroying an artwork. Anyway, why does the big picture look like this? I'll tell you. It's always like the intellectual property environment that we live in. It's always available for use. It's heavily criticised, particularly by experts, despite its value. It's definitely a mess. And it looks quite different, depending on whether you're looking at it from one side or the other. And if you're in it, you can't even see the mess. It's a facility which can be enjoyed by many different stakeholders, whether alone or in combination with each other. And with a little tidying up, it should be just fine. And it can generally benefit by being changed from time to time. Thank you. Again.
Now we have very good time for questions and comments from those of you in the audience physically with us. So those who'd like to make a question or a comment, please wait for a microphone to come to you so that we can all hear it and the recording can capture it. We have microphones to be delivered. So anyone who would like to make a comment or question, please raise your hand now and Jeremy will deal with it.
Marcus Wigan. One of the things that's most interesting is that there's a heavy use of trade agreements to standardise globally and also to increase the permanent ratchet upwards. I'd be interested in both halves of that comment being taken, the TPP, the transatlantic partnership, and the other characteristic is these are never done in the open, but only in the dark.
Yeah, and I am horrified at the thought of any publicly appointed bodies negotiating things such as the ACTA in the first place, the TPP and the TAP, in such clandestine situations. It's not as if we're talking about things which don't exist in national law. We're talking about enforcement of intellectual property rights, and I think that the population of every country in the world that has a democracy and that is able to vote its politicians in and out is sophisticated enough to understand what is actually being debated. I saw nothing at all in ACTA, and I saw nothing in the text of one of them I couldn't see, the other one I could. I think it was the TPP I did see in the end. I saw nothing that could cause anybody to support the principle that it had to be conducted in a clandestine manner. If intellectual property is important and has value, this should be explained and opened up to people so they can see what their governments are trying to agree. So I'm mortified by that. With regard to bilateral trade agreements rather than the sort of plurilateral ones, I watched them with a mixture of interest and suspicion. Interest because in the days before we had the Paris Convention and the Berne Convention, the only way that you could establish intellectual property mutual recognition between countries was through bilateral agreements. And in a way, the norms of Berne and Paris reflected a whole bunch of bilaterals. But I'm also suspicious because when I look at them, some of them seem to be tremendously one-sided in terms of the benefits conveyed by each. There's a recent one negotiated by, I think, 3 of the Latin American countries with the European Union, which covered, amongst other things, geographical indications. And they said, yeah, we'll protect your geographical indications if you protect ours. And there was a list of geographical indications to be protected in these countries from Europe. And it was pages and pages long. And there's only about half a dozen GIs that were going to be protected in Europe from these people. And I thought, well, you know, it does seem that one side is getting rather the better of the bargain than the other. Having said that, there's more to the bilateral agreements than just the IP. And if I were negotiating one of those bilaterals, I would expect to see a quid pro quo. And if I was going to be protecting somebody else's intellectual property rights, possibly to the detriment of my own local industry, I would want to see something back in terms of money, capacity building or support that would make it worthwhile for me to do that.
Yes, up, 10 rows up there, thank you.
Incidentally, the European Patent Office don't get to see these confidential negotiations either. The IPCAT has received email requests from people at the EPO to provide them with a copy.
Hi, I'm Angela Daly. I'm from the Swinburne Institute for Social Research here in Melbourne, and I am a one-time IPCAT guest writer. So, Jeremy, it's great to see you in person, and thank you very much for your lecture. What I did want to ask, though, is that if so many IP academics seem to kind of not think very much of IP, and bearing in mind these are people who are not beholden to their clients' interests as possibly lawyers in practice are, and are actually often creators and users of IP, well, if they all are thinking that the IP system maybe isn't so great or is broken or whatever else, do you not think they might be right? And if you don't think they're right, which I guess is your position, why do you think they have this bias, or so-called bias?
Okay, Angela, first, lovely to see you. I've got a rough idea of who you are. I didn't say that they're wrong. I said that they were biased. Now, if you're biased, it means that you take an opinion and you're not amenable to arguments, you're not amenable to facts, because that's your opinion, and that tilts you whatever you're doing. If you support that with facts, if you support that with reasons, if you do something about it, then that's absolutely fine. Take Larry Lessig, a person who is a distinguished US academic. I have disagreed with him on a number of occasions about a number of things, but he is a very positive person, and whenever he disagrees with me, there are always total reasons for his disagreements. He doesn't argue and say, well, I think this is wrong because I think this is wrong. And I get that in things which are sent to me. He says, I think this is wrong because, and it has to be put right because, and people like Larry Lessig I respect. What did he do when he didn't like the way that copyright was working in the States? He set up Creative Commons. Mark Lemley didn't like the way that people were making suppositions about patent litigation instead of finding out the facts. So he set up Lex Machina. You know, if there's something wrong with the system, address it objectively, deal with it. But I get things, 3 times this year, I've had articles from academics on trademark law, which have a sentence which goes like, the function of trademark law is consumer protection. And I looked, is there a footnote? Is there some source to protect that? And I turned to the European Trademark Directive on Harmonisation. And I said, well, does it say anything about consumer protection and being the objective of trademark law? No. And I look at the Community Trademark Regulation, perhaps that does. No. And I look at the Trademarks Act 1994. No. And look at the Paris Convention. No. Look at TRIPS. No. There's nothing about it. It's an assumption. And it's a false assumption because there's nothing to support it. The function of trademark law is not consumer protection. It's a beneficial byproduct. But what is the consumer? The consumer is, in the olden days, in mines, they used to take a canary down in the cage. And if there were noxious gases that were being generated in the mine that would be likely to kill the miner, the canary would drop dead and fall off its perch. And they would say, well, let's get out of this mine pretty quickly. The role of the consumer in trademark law is like the role of the canary. If the consumer is confused, then the trademark owner gets damages or an injunction. But the consumer who is confused has no remedy under trademark law. And yet I keep getting this thing, the function of trademark. And they say, well, of course, trademark law is failing the consumer. And having said that that's the purpose of it, they then go on to say that it's not doing the job, which they've deemed it to be its prime job to do. And there's no support for it. Patents is another example as well, where people would sooner quote newspaper articles saying that people have patented particular things which happen to be in the public domain and which are incapable of being patentable, rather than looking at the patent itself and seeing, well, actually what was patented wasn't this product which is in the public domain. It was a process for getting it, which wasn't in the public. You know, there's a sloppiness of thought which goes with the bias. You find the article necessarily, or the sentiment that goes with your emotions and you run with it. Academics shouldn't be doing that. Academics should be shedding a light on the subject. And one of the things I do, sorry about this, when I'm editing GitLib, all our articles are peer-reviewed. And what I like to do, if I get an academic article, I send it to a practitioner to review. If I get a practitioner's article, I send it to an academic to review. And on the whole, the academics are very, very warm and encouraging towards the practitioners' articles. Whereas the practitioners are saying, well, hold on, this person is producing book learning which doesn't seem to fit with what actually happens in practice. And they seem to have an attitude. So if you're an academic and you're out there, tighten up on your discipline. You don't need to be biased in order to be right. Argue your case. Found your case properly. I've published articles that I totally disagree with because they're well written and they fit as articles. And I've published blog posts from guest bloggers that I totally disagree with because they are sensible material which is firmly based. Don't base yourself on bias. Base yourself on reality. And then you'll persuade other people. Okay.
Yes, we'll take
Yes, my name is Xiu. I'm an engineer by profession. In your opinion, do you think the public, including the younger generation, has adequate knowledge or education about the importance of IP? Because nowadays, because of the proliferation of the electronic media, this thing is not easily monitored.
Yeah, I think that the younger generation in general have an insensitivity towards intellectual property rights. I don't expect them to have a deep and detailed knowledge, but there was a time when it was generally understood, for example, that copying was wrong. Plagiarism was wrong. Now, universities and publishers have to resort to sophisticated means in order to discover whether essays, articles, dissertations are plagiarised, because there seems to be a norm that it's acceptable. And with regard to other areas, you're an engineer. Some years ago, I was asked to do a set of lectures on law for engineers. And I said, that's great. I'll tell them a little bit about what they can do if they come up with a new idea. That it might be something they can patent, it might be something they can get money from, it might be something which would be worthwhile. And I was told, no, don't teach them about that, they'll never need it. Teach them about what happens if they lose their jobs. So, once again, people don't know enough. And I can't blame them. I mean, people only want to know things when they need to know them. And before the stage at which they need to know them, it's just too much information. I think we have to educate in a very gentle way. I really hate Wallace and Gromit. Are they big in Australia? Are they known in Australia? Yeah. Well, because to me, they totally trivialise invention and the concept of intellectual property. And yet the Intellectual Property Office in England tell me that they have a profound and lasting educative effect upon the young, in that they sensitise them to the advantages of an intellectual property system. So they may be right, I may be wrong. I've asked them, can they please keep a track in future years of how many patent applications for national patents were influenced by Wallace and Gromit when they were younger. And then we've actually got some data on which we can resolve this. But it might be one way of doing it.
Over here on this side, we've got a question.
Hi, Jeremy. Rebecca Giblin. Hi. I don't have a big question about the big picture, but I've got a question about the little picture, and we're all wondering. Can you tell us about the cats?
Okay. Over the years, we have reproduced well over 30,000 images on the blog, of which a good 1/3 are cats. Now, of these cats, a substantial proportion of them are readers' cats, and they are sent to us by IPCAT readers far and wide. I have a big folder on my computer marked readers' cats, and I dip into it from time to time for cat images. I have to say that on the whole, whatever their virtues, intellectual property lawyers do not make the best photographers of cats, even though they generally photograph figures sitting or indeed a sleeping target. And black cats do not make for good photographs because they just look like a big black puddle. So we get a lot of readers' cats. A lot of the cats that we use are public domain cats. Some of them come from clip art or free art. Some of them are cats which have fallen out of the copyright protection entirely. Some 19th century cats. You've got Lewis Wain cats. Some of them are cats which we have taken slight liberties with because we have decided that they've fallen within the scope of fair dealing. And now from the 1st of October, we have an extra defence upon which to rely, which is parody. And if we can use cats in the course of parody, then we will be even more free. Funnily enough, in the 11 years that we've been using images, we've only actually had one allegation of copyright infringement. And that was from a gentleman who asserted correctly that we were infringing his copyright. We were infringing it in Canada, but not in the UK. And he sent me the provision of the Act which supported him, and I sent him the provision of the Act which defended us. And I said, well, we don't actually have any assets in Canada, but we have an automatic takedown policy. And if anybody objects to any of our artwork, we will always substitute it with another piece, because we don't want to make enemies.
There's a question over here. The microphone's down. And are there others? If people want to just show me with your hand if you've got questions, so I can know in advance. Okay.
Aaron Morey from the Productivity Commission. There's been some calls for a higher level review of whether the right balance is struck between the extent of IP rights and their use in this country. You've noted the dangers of overgeneralising and your perhaps sceptical view or the narrow view of economists. So what role do you sort of see for broad policy guidance, especially in the context of emerging issues like in software sort of related innovations and the like.
Yeah, I'm absolutely certain that there is a role, and I think that that role has to be broken down by sector and by type of intellectual property right. Because the moment you're generalising across, for example, the cosmetics industry, the luxury goods industry, the pharmaceutical sector, electronic engineering, you're prescribing at too high a level. And what I would like to see is reviews which are conducted at a smaller level. Look at it this way. When we started off with intellectual property, there was only one right, and that was the patent right. And from the 14th century until the 18th century, if you had an invention, it was a patent. You wrote a book, you get a patent. I speak in general terms, but that's usually the case. If you had a good trade monopoly, you got a patent. But now we have patents, copyrights, trademarks, design rights, semiconductor topography rights, database rights, rights in technical information, geographical indications. Every different type of market and every different type of way of doing things in a market requires its own bespoke protection. And it's reviews which can point out where protection is not working or it is working, which can help to direct us in that regard.
Okay, we have time for one more question. We've got one up there on the...
I wasn't going to say anything because I'm an economist and I didn't want to engage in an outright warfare with you. But just your last comment, though, worried me because I've been looking at I think it's the Donaldson case, the copyright case, and the US Supreme Court interpretation of that. You just commented that the only right was one right, patent right, but the House of Lords held by a majority that actually the copyright was a right in common law in perpetuity, albeit taken by the Statute of Anne. So I thought, I'd ask for your insight on that.
Yeah, well, funnily enough, I've just been looking at an article on the revisionist view of Donaldson and Beckett and common law copyright. Yeah, common law copyright was said to exist, but to all intents and purposes as a commercial entity, it only existed within the confines of that case, because it didn't exist in terms of publishing and licensing. And once that case was there, they said yes, it existed, and they got anyway. That's. Well,
I'll just make my one big economic point anyway,
sure.
In terms of the big picture.
Go ahead.
which I think is basically the problem of creation costs. I think that's the big picture.
Yeah.
And that's the common factor across patent, trademark, and copyright. And Harold Dempster's pointed out that economists are used to analysing the world with goods as they already exist, like oil in the ground or things that are manufactured. They're goods that already exist. Competition between manufacturers and producers of goods that already exist is different from competition with a creator who incurs creation costs, which are fixed costs like other costs. But the problem with creation costs is your competitor basically just copies what you do and doesn't incur creation costs. And so that undermines the incentive to create, but also the incentive to take to market, to do what Adam Smith said about truck and barter. And so, I think that the law and economics insight about intellectual property rights does provide the big picture, because all I actually get, and I have to say it, because you've been critical of economists, was a series of partial views from you, actually, about how there were intruders and, there was this right and that right and so many different agencies. And to some extent, you sound like someone in a world of intellectual property who've all of a sudden discovered the rest of the world and all these things intruding on your space. So, but I think, I make the comment that creation costs are the unifying problem, and without the rights, you don't get the incentive to invest, you don't get the incentive to take to market. And that's the case with copyright, of course. There was very little scope for copying before Donaldson and Beckett. If you had to get a monk to sort of write things out for you, until the printing press came along and they had to deal with that with the Statute of Anne.
The printing press has been going for 300 odd years before Donaldson and Beckett, and you've proved my point as well. What are the creation costs of me wanting to assert that I and not somebody else was the author of a book which you've published in somebody else's name? What are the creation costs of me asserting that you have distorted my work by doing things to it which I didn't authorise? What are the creation costs of me protecting my right in my name? You're taking an economist's view. No. The one does not exclude the other. And I haven't just discovered the rest of the world, I've been living it for a long time. But if I was giving a lecture to a group of people none of whom were intellectual property people at all, I would have given a very different lecture from the sort of lecture I would do to a group of people who are all brought together by a common interest in intellectual property. And within the confines of a 45-minute lecture, it's not actually terribly easy to give a total coordinated picture of intellectual property inside and out as it interfaces with all the other disciplines and phenomena in the world in which we live.
Okay, now well, in a moment you'll be doing that again, so that was good practice, but we want it twice as loud and twice as long. But before we get to that, I call on Janelle Borum, IPTA counsellor, to bring proceedings to a close.
Great, thank you. It was a great pleasure to hear from Jeremy Phillips today to speak to us about IP in transition, desperately seeking the big picture. Jeremy took us through a series of short points, he told us, which he suggested may be in no particular order, but I found to be actually very well ordered and led very nicely to that final image. We've had the opportunity to think in depth about the IP picture, which rights fit into the picture, and whether there has been any intellectual input into all types of existing IP rights at all. He recognised the intruders into IP, and examples were provided of the dangers of generalisation. Many players are in the scene, and Jeremy provided some great examples of how they each approach IP differently. And I think many of us here enjoyed the reference to policy-based evidence, and I can see myself referring to this again. Finally, Jeremy led us to the image of the messy but rather expensive bed that is quite representative of intellectual property. So thank you very much, Jeremy, for coming here and presenting this lecture on your grand tour here to Australia, and we hope to see you again, hear from you either through one of your blogs or preferably in person. Thank you.